Okay, so today we're doing a deep dive into a really pivotal case, one that shaped how we look at the death penalty in the Philippines.
That's right. We're focusing on the 1997 Supreme Court resolution. It deals with Leo Echegaray's conviction and death sentence.
And this was under the then new death penalty law, RA 7659.
Exactly. Our main goal here is to unpack the supplemental motion for reconsideration his lawyers filed. They raised 7 points, but one really stands out.
Which one was that?
The big one, number 7, challenging the constitutionality of RA 7659 itself. That was the core fight.
Right. But before we get to the constitutional battle, they did try a couple other things, didn't they? Some procedural arguments.
Yes, the new counsel, FLAG, raised 2 key non-constitutional points first, almost like clearing the underbrush.
Okay, what were they?
First, there was this affidavit of desistance, basically a document suggesting the victim, through her mother, wanted to withdraw the charges. The defense hoped that would stop the prosecution cold.
An alleged pardon, essentially. How did the court handle that?
They dismissed it pretty quickly. The victim had signed it, yes, but in open court, she strongly pointed out that she is not withdrawing the charge.
Okay. So her direct testimony trumped the paper she'd signed earlier.
Precisely. Her statement in court was what mattered. The signature wasn't enough when she stood by the accusation face to face.
Okay. And the second procedural point?
That was about the previous defense lawyer. They claimed he was incompetent, leading to a denial of due process.
Another common defense tactic. Did that stick?
No, the court didn't buy it. They found the former counsel had shown ordinary diligence, which is the standard.
So, not incompetence.
Right. The court basically said the issue wasn't the lawyer, it was the sheer weight of the prosecution's evidence against Echegaray. It was just overwhelming.
So, with those procedural arguments off the table, it all came down to the law itself. Was RA 7669 constitutional?
Exactly. And this digs into some interesting legal history. The death penalty wasn't new. Under the old penal codes going way back, it had generally survived challenges claiming it was cruel and unusual punishment.
But then came the 1987 Constitution. That changed things.
Massively.
Mhm.
Article 3, Section 19, Paragraph 1, that's the key.
Remind us what it says.
It's quite specific. Neither shall death penalty be imposed unless, for compelling reasons involving heinous crimes, the Congress hereafter provides for it.
Unless Congress hereafter provides for it. That phrase. That's everything.
It really is.
Yeah.
And if you look at the records from the Constitutional Commission, the Con and Com debates,
Yeah. What do they show?
they showed this wasn't accidental. The framers deliberately chose not to abolish the death penalty completely.
So it wasn't abolition. It was more like a suspension.
Exactly. They suspended it, but built in a mechanism for Congress to bring it back if they felt there were compelling reasons, specifically for heinous crimes. It was a compromise.
They rejected the absolute abolitionist view and left the door open.
Right. They wanted flexibility, maybe anticipating future crime waves or particularly awful offenses.
And Congress eventually decided those compelling reasons existed.
They did. RA 7659 took effect December 31st, 1993. Its whole purpose was to restore the death penalty, but only for those heinous crimes.
How did the law itself define heinous? That sounds potentially subjective.
Well, the preamble of RA 7659 uses very strong language. It calls them grievous, odious, and hateful offenses,
Okay.
which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity are repugnant and outrageous to the common standards and norms of decency and morality.
Wow, that's quite a definition. Very morally charged.
It is. It sets a high, though admittedly somewhat interpretive, bar.
So let's pull this together for you listening. The Supreme Court looked at all this. The Constitution, the CONCOM debates, RA 7659.
And they concluded.
They concluded that the 1987 Constitution didn't abolish the death penalty. It just put it on hold. Congress had the constitutional power to bring it back for heinous crimes, which it did through RA 7659.
And Echegaray's crime clearly fit the definition of heinous under that law. So the law and the sentence were upheld.
The conviction stood, and the framework for capital punishment was validated.
Yes. But here's a final thought for you to chew on. Even though the death penalty was restored constitutionally, the law itself, for many of these crimes, set the penalty as reclusion, perpetual life imprisonment to death.
Ah, so it wasn't an automatic death sentence.
Not always. It created a range. Getting the actual death sentence usually requires the trial court to find specific, aggravating circumstances that make the crime truly heinous in that particular instance.
Meaning the judge has discretion.
A significant amount. Which raises a question. Who is really defining heinousness in practice? Is it the legislature with its broad moral definitions, or is it the judiciary, case by case, deciding when to impose the ultimate penalty? That tension, that's still debated today.